The defendant is present in the courtroom. Her attorney, Nicolette Tomaszek, are before the court for purposes of a change of plea. It is my understanding the defendant wishes to withdraw her previously entered pleas of not guilty and plead guilty to the indictment. That the all three counts and the forfeiture specification attached to count one. Parties are ready to go forward.
Is there any discussion with defense counsel regarding any recommended sentences?
No, Your Honor. The state is not committed to recommend one sentence or another. The state has said that it would consider the defendant pleaded guilty here, but there's no agreement or no commitments.
Thank you. Ms. Tomaszek, does that all sound accurate?
Yes, Your Honor, that is my understanding today.
And Ms. Kakowski, were you able to hear what the prosecutor had to say regarding what he believes your intentions are here today?
Yes.
He indicated to the court he believes it's your desire to withdraw your previously entered pleas of not guilty and plead guilty to the three charges in the indictment, and I'll go over those with you to make sure you understand them. We would then continue the sentencing to a later day to get some evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, more importantly, what you want to do today?
Yes.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right? You have to say yes or no.
Yes.
Thank you. All right, let's get started then. How old are you?
33.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this afternoon, have you any drugs or alcohol of any kind?
No prescription medication.
Okay, well, that's my next question, on whether you're taking even taking any prescribed medication. So you've had some prescribed medication within the last 48 hours?
Yes.
What would that be?
For high blood pressure and anxiety.
So just the two medications?
Yes.
When's the last time you had those?
This morning.
Do either of those medications affect your ability to understand or appreciate where you are or what's going on around you or anything like that?
No.
So you're not under the influence of either of those medications right now in a negative way, which is negatively impacting you in any manner?
No.
All right. Now, you would have received a copy of the indictment in this case. It looks like you got it back last spring, around the beginning of April of not last year, but this year, but this past spring. You remember getting that document at some point?
Yes.
And had a chance to look that over at some point?
Yes.
Now, in that indictment, you're charged with 3 counts. Count 1, and you're pleading guilty to all 3 of these counts. Count 1, it's alleged, and what you'll be admitting to is on or about April 13th, 2021, in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance which contain cocaine. The amount involved did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes.
Any questions about that for me? Now, count 1 also carries with it what's called a forfeiture specification, which alleges that you possessed or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal just by the nature of the property itself, like drugs. An instrumentality is some type of property that there may not be anything illegal about it in and of itself, but it's being used in an illegal manner to facilitate a crime, and you can't use or possess it for that purpose. And here it's alleged that all the drugs, the paraphernalia, and the instruments confiscated are considered to be instrumentalities or contraband. The whole point of this is that you forfeit any ownership interest you have in any of that property. It allows the state to be able to dispose of that property at the end of the case. It doesn't increase any potential penalty you face, except that you lose your ownership interest in it. Do you understand that?
Yes.
Any questions about that?
No.
Now, in count 2, what's alleged here and what you're admitting to is on or about April 13th, 2021, in Mentor Lake County, Ohio, that you didn't knowingly obtain, possess, or use a fentanyl-related compound or any compound, mixture, preparation, or substance containing a fentanyl-related compound. The amount involved did not equal or exceed 1 gram, which makes the offense possession of fentanyl-related compound a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes.
Any questions about that for me?
No.
Lastly, in count 3, what's alleged here is on or about April 13th, 2021, in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use alprazolam, diazepam, clonazepam, and zolpidem, or any compound, mixture, preparation, or substance containing those drugs. Those are a Schedule 4 controlled substance. It's further alleged that the amount of those drugs did not equal or exceed the bulk amount for those drugs, but that you have previously been convicted of a drug abuse offense, being drug possession in Cuyahoga County and or possession of a drug abuse instrument in Rocky River. That conduct, along with the prior convictions, constitutes the offense of possession of drugs. It's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 3?
Yes.
Any questions about that for me?
No.
So you understand the nature of the 3 charges you're pleading guilty to?
Yes.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you are giving up. And you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that decision whether you're guilty or not guilty of each charge. But you also have a constitutional right to have a jury trial. A jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be unanimous. That means all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty of each individual charge. You understand that?
Yes.
Do you understand by pleading guilty or giving up your right to have a trial in this case?
Yes.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio. He would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. What it means, it's the amount of the evidence and the quality of that evidence the state has to present in the trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of all these charges beyond a reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes.
You understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt of these charges?
Yeah.
Now, in order to try to do that, if we were going to have a trial in this case, the prosecutor would be bringing witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. She could ask them anything she wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right? Now, you also have a right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you and you alone would have to make. Do you understand that?
Yes.
So what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, he's not allowed to call you as a witness and make you get up on the stand and answer questions and testify Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Do you further understand that if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions? By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. The court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Can you say that again?
Yeah, look like you had a question about that. By pleading guilty, you're giving up your right to appeal a guilty finding. So if I accept your plea of guilty, I'm going to find you guilty. You're not going to be able to appeal that or challenge that at a later time. You're also not going to be permitted to appeal any issues that have been raised so far that you disagree with the ruling on, if there is any, or that you could have raised but you haven't so far, but you were able to. You're not going to be able to raise those later. Do you understand that?
Yeah.
Do you have questions about that? You want to talk to your lawyer about that, or you can ask me, whatever you want to do, but
Can I
want a
have a
minute to
moment,
talk to your lawyer? Go ahead.
What?
I'm ready to proceed, Your Honor.
Do you have any questions for me at this point? Are you ready to continue?
Yeah.
All right. So do you understand what I just explained to you then about giving up your right to appeal any issues that you could have raised so far, or finding it guilty?
Yes.
Okay. All right, then you understand all the rights we've just discussed? These are all the rights you have and all the rights you give up by pleading guilty. Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Do you understand a guilty plea is a complete admission of guilt? So it means you're admitting to the facts being alleged by the prosecutor. We're not going to argue at any later time that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court of these charges, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to 3 felonies of the 5th degree. Each of these are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes.
Now, since there's 3 charges here, if a prison sentence is imposed, I would impose a prison term on each count. And then as the judge, I have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together at the same time. You'd serve those terms at the same time. Whereas consecutive means one after the other. You'd serve the prison term for the first count, finish it, whatever it is, then the second count, and then so forth. Do you understand the difference there?
Yes.
So in this particular case, if I impose the maximum sentence on each count and ran them each consecutive, you're looking at a maximum possible prison term in this case of 36 months or 3 years in prison. Do you understand that?
Yes.
Now, are you currently on probation or parole or any type of supervision in any of their courts or agencies?
No.
Do you have any other criminal charges pending against you anywhere?
No.
If a prison sentence is imposed in this case, upon your release from prison, you could be put on what is called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after, after you completed your prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes.
And if you were on post-release control at any point, never violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
All right, now in addition to the possible prison term that I just explained to you, there's other sanctions or penalties that could be ordered. You could be fined in this case. Each of these counts carries with it a possible fine of up to $2,500. So altogether, that's a maximum possible fine of $7,500. I could order that you pay court costs. I could also order that you reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes.
I could also suspend your driver's license for up to 5 years. Do you understand that? And lastly, as I alluded to a little earlier, any right, title, or interest you have in any of that property that's in the forfeiture specification will be forfeited to the state of Ohio. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence. When I did that, I used the word possible. Prison's not mandatory with any of these charges. You are eligible for probation, or what we call community control sanctions. Do you understand that?
Yes.
Now, do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information presented. then I'd make the decision I thought was the right thing to do. Do you understand that?
Yes.
Now, if you are put on probation, it could be for up to 5 years. And as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes.
Further, if you are on probation, excuse me, and you ever violated any of the rules or conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could order more restrictive sanctions against you, including order that you serve time in our county jail. Or I could terminate your probation and send you to prison at that point. And if I did it at that point, again, it could be 6 to 12 months in each count. I could run all those consecutive for 36 months in prison. And that could also be consecutive to any other prison sentence you may be serving on some other case, if there's a new case that you pick up or that you're being sentenced to at that time if it's some new case. You understand that?
Yes.
Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. She can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty here today?
No.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to talk about this case with your lawyer and have her go over everything with you and answer your questions?
Yes.
Are you satisfied with her advice and counsel?
Yes.
Has she, or has anyone for that matter, made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty today?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering this guilty plea freely and voluntarily?
Yes.
All right, then, do you have any questions for me at this point regarding anything we just talked about? What you're pleading guilty to, the rights you have, any of the penalties you face? Any questions at all?
No.
Do you need any more time to speak with your lawyer before we go forward with your change of plea?
No.
All right, then what we're going to do at this point, the prosecutor here is going to explain for me what he believes the facts would show if we had a trial. I want you to listen to him, because I'll have some questions for you about that then, all right? Mr. Shapiro.
Thank you, Your Honor. The evidence would show April 13, 2021 in the city of Mentor, Lake County, Ohio. Mentor Police Department received a call about an unresponsive female in an Uber ride share. Police responded to the address of the caller. It was on the street in front of a home in the city of Mentor. They found the defendant to be in the back seat of that car, unresponsive, administered Narcan. She came to. She was the only occupant of the vehicle other than the driver. She had some property in the car, the defendant did, and amongst that property was a purse that contained drugs, specifically cocaine in an amount less than 5 grams in a sealed envelope. Also, there was fentanyl, and that cocaine is Schedule 2, is confirmed by the crime lab. Also, fentanyl was also in another sealed envelope in that purse, Schedule 2, controlled substance, confirmed by the crime lab. And there were a number of pills also in a pill bottle, and that was alprazolam, diazepam, clonazepam, and zolpidem, all Schedule 4 controlled substances, confirmed by the crime lab. And the defendant at that time had been convicted of a drug abuse offense as enumerated in Count 3 of the indictment. The state incorporates into its oral recitation of the facts right here, the specifics of those. And that's it, Judge.
Thank you. So were you able to hear what the prosecutor just had to say?
Yes.
Were you able to hear what the prosecutor just had to say regarding what he believes the facts would show if we had a trial?
Yes.
What, if anything, you have to say about those facts as he just presented them? Are they true? Did you do what he said?
Yes.
Very well, then regarding Count 1, charging you with possession of cocaine, with the forfeiture specification of felony to the 5th degree, what is your plea to that?
Guilty.
Regarding Count 2, charging you with possession of a fentanyl-related compound, of felony to the 5th degree, what is your plea to that?
Guilty.
And regarding Count 3, charging with possession of drugs of felony to the 5th degree, what is your plea to that?
Guilty.
All right, I have in my possession here a 4-page document called a written plea of guilty and judgment entry which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document. Excuse me. And that you sign it here in an open court. Now, my understanding is before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes.
Ms. Tomasic, is that accurate? Did you read this over with your client, review it with her, answer her questions?
Yes, Your Honor.
Did she indicate an understanding of it to you when you did that?
She did, Your Honor.
Is that correct?
Yes.
So you understand what the document says?
Yes.
Do you have any questions for me about it?
No.
Now, it also appears you signed this document. Did you sign it before I came out here?
Yes.
And you witnessed that, Ms. Tomasic?
Yes, Your Honor.
Mr. DePiero, you as well?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, with her lawyer, advised of all our constitutional rights and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas. Find the defendant guilty of count 1, possession of cocaine, a felony in the 5th degree, in violation of 292511 of the revised code with the forfeiture specification. Count 2, possession of a fentanyl-related compound, also a felony in the 5th degree, in violation of 292511. And count 3, possession of drugs, a felony in the 5th degree, in violation of 292511. I will defer sentencing, order a pre-sentence report investigation, drug and alcohol evaluation, and bond will remain revoked. Is there anything else for the record at this time, Mr. DePiero?
He was found unresponsive in an Uber, revived with Narcan, and brought to court, where the judge walked her through every charge and finally revoked her bond. What do you think about the judge's decision? Let me know in the comments.